Respected Madam Yusrina Abu Bakar, Acting Chief Librarian, al-Hikmah Library IIUM. Respected panelists, Encik Muhammad Shafiq Abdul Latif, Assistant Director, Copyright Division, Intellectual Property Corporation of Malaysia, MyIPO, academics and researchers, library top management, senior management, head of units, and colleagues from Darul Hikmah Library IIUM. Officers within IIUM and without, ladies and gentlemen, Assalamualaikum warahmatullahi ta'ala wabarakatuh, and a very good morning. To gain barakah of our event, let us start with lafaz Bismillahirrahmanirrahim, and let us make dua to Allah to bless our event and hope our session today will be beneficial to all. Ladies and gentlemen, we wish to extend our warm welcome and thank you to all special guests and all participants in this webinar on Stop Piracy, Save Copyright. This webinar is brought to you by Darul Hikmah Library via Zoom platform and live streaming at the official IIUM Library YouTube channel. I am Irni Izwah Bakar, your moderator for today. As IIUM researchers secure their research by filing copyright, let us get insights about copyright-related matters from the key player of the intellectual property industry itself, the Intellectual Property Corporation of Malaysia, MyIPO. Inshallah, in this webinar, we will share what are the benefits and rights after copyright application has been approved by MyIPO, what you should do when you notice unauthorized use of copyrighted works, and many more. Hopefully, all of us will be able to reap as many fruitful inputs and tips, inshallah. Before we proceed, we hope that all participants can fill in the attendance. The link for the attendance is available in the chat box. Inshallah, we will take a group photo at the end of this session. Participants may use the program background provided in the Zoom chat box. Ladies and gentlemen, we are very honored today to have our invited panelists from MyIPO. While listening, for the Zoom participants, if you have questions, you may unmute yourself and ask questions verbally. As for the YouTube participants, you are free to post questions in the chat box and we will read your questions. It is my pleasure to introduce our panelists for today, Encik Muhammad Shafiq Abdul Latif. Assalamualaikum, Encik Shafiq.
Waalaikumsalam.
Right. Allow me to introduce Encik Shafiq. Encik Shafiq is currently the Assistant Director of the Copyright Division, the Intellectual Property Corporation of Malaysia, MyIPO. He assists the Director of the Copyright Division and Copyright Controller in monitoring copyright legislation and regulations, as well as he is responsible to ensure effective compliance with the Copyright Act 1987 in Malaysia. He holds a Bachelor of Law and Bachelor of Laws in Sharia from the International Islamic University, Malaysia, IIUM, in 2013. He then acquired his Master of Laws in Sharia from the University of Malaya, UM, in 2018. On 5th December 2014, he was called to the Malaysian Bar as an advocate and solicitor of Malaya. Currently, he is pursuing a PhD majoring in copyright law at University Kebangsaan Malaysia, UKM. And now, presenting to you, ladies and gentlemen, Encik Muhammad Shafiq Abdul Latif. Please welcome.
Assalamualaikum warahmatullahi wabarakatuh, and very good morning to audience and participants. Thank you to Ms. Moderator for moderate this event. And I was truly grateful to International Islamic University Malaysia, particularly with the Darul al-Hikmah Library, where I am a homegrown student in IIUM, so it is a great pleasure to be invited to this webinar and also giving back my knowledge to my alma mater. And first of all, I do take note that we have online, we have 26 participants. This webinar is also being streamed in the YouTube channel, and also most of the participants have a various background. Most of them from the researchers, students, lecturers, and so on. So I'm truly grateful to be invited to talk to this meeting. And briefly, I'm in 7 years in MyIPO, so I've been practicing copyright. So I'm advocating copyright on the importance of copyright registration on how it could benefit researchers, students, lecturers in lieu of your research making progress. And also, so my lecture today I would like to do it informally. So if you have any questions and answers, if you're afraid to ask verbally, you can put it in the chat box. I think YouTube have a live chat box also. So perhaps moderator will assist me in dropping some questions, and I will honored to answer instantly, during the lecture. So without further ado, I will just start my presentations. Yep. Okay.
Yeah, sure.
Okay. Okay. So our topic for today is actually entitled Stop Piracy and Save Copyright. So since most of you has registered your copyright material ready, and this webinar will also enshrine or highlighting some important elements on what are you going to do after you secure your copyright, what rights you will be getting after securing your copyright, and also benefits in terms of initiating an infringement, initiating a complaints, and so on. So before I'm discussing on your rights to copyright, I think it's very mature if you can actually discuss what is copyright itself. So this is an exhaustive list of our webinar today. I will not go through the most of the slides. I will skip some less important slide and highlighting what is important to our webinar today. Okay, so trace back in the history of MIPO. So I think most of you has already known what is MIPO. So basically, we are actually in 1983, we are the government arms. We are sitting under the Ministry of Domestic Trade and Consumer Affairs, or known as KPDNKK. Before we are being corporatized in 2003. So previously we don't have a copyright division. We only have a trademark division, patents division, before we are moving into the special intellectual property division. So as MIPO, we are self-regulatory body. We actually administer intellectual property filing applications and administers these 7 acts through our agencies, which is the Intellectual Property Corporation Act, Patents Act 1983, Trademark Act 1976, ID Act, Copyright Act, GI, and Layout Design Integrated Circuit. So most of our webinar would focus only this act, which is the Copyright Act 1987. So I will not touch other elements, but I will give you an overview what is the other IP instead of we are focusing more on copyright, because you will see that we also need to know other intellectual property other than copyright. So I will just give a 10% overview and then focusing more on what is copyright. Also, we have the Intellectual Property Court. We have a special court established in 17 July. We have in various parts of the states in Malaysia. Okay, so introduction to intellectual property. So I will just give an overview, perhaps in 5 to 10 minutes, on what is IP, since we have many hours to go, about two hours more. And intellectual property is actually reserved for type property that result from the creation of human mind. So in order to protect intellectual property, you have to express it into a material form. Let's say, for example, you have an idea on how to actually write a journal. So you must actually write the journal in a book, in a piece of paper. Then it will only be protected as intellectual property, since it is a tangible work. So why intellectual property is actually given? It is a common it is a common in intellectual property scene that it is given to capital expenditure for a new product, for R&D, for marketing, no-fee riders, maintaining loyal followers and profit. So when a person registers their intellectual property or copyright, for instance, they must have a main purpose, which is, for me, myself, is to commercialize my work, is to commercialize my research. So that's why we need IP in exchange of something which is a profit. And another reason for having intellectual property rights is we want to actually put a justice to a person to actually create the work, protect their work from being infringed by a third party, a culprit or infringer, encourage them to grow, to make a new work every day. So if a person doesn't have an innovation in a year, for example, we don't have any new emerging technologies exist in today's world. For example, we have an iPhone 6 back in 2015. Now we have an iPhone 14. So if someone don't creative enough and don't innovate for a new creation, so iPhone 14 would not exist in 2022, for instance. So the purpose of IP to actually encourage them to grow and protect the ideas underlying on their creations and innovation. In intellectual property regime, for instance, the government, which is through MIPO, when you register your copyright, for example, so in exchange, the government or through Copyright Act 1987, give you a monopoly over your creation. This is a monopolistic right nature. When you secure your copyrighted works, the government gives you a monopoly right in exchange of the registration. So what is actually a monopoly right? So monopoly right, it comes when, let's say, you want to actually sell your works to a third party, you can do that. And if a person wants to use your copyrighted work, they must require your permission. So you control your permission. That's the monopolistic nature that you have over your creation of copyrighted work, which is given through a Copyright Act 1987. So this is an example of our legendary singer, actors, and also writers across various parts of the copyrighted works. He have a sound recording work, he have a film, he have a various type of work. So this is in Malay. Okay, you can read it by yourself. Okay, so still they have any problems in terms of royalty. So most of the P. work, for example, a film is not owned by the P. kings, and it's not owned by their kings. Most of this film is owned by Shaw Brothers, which is based in Hong Kong, and his sound recording created is owned by EMI Music Publishing. So there is a revolving issues why P. king is not due to the royalties, because actually most of the work have been transferred to other person. So when you secure your copyright, your royalties are given to you. So at the first place, if you don't actually want to commercialize your work, don't actually want to commercialize your copyrighted work, you can sell your work. When you sell or sold your work to a third party, you doesn't retain your rights anymore, and the royalties paid are not due to you. So this is what happens when you are not actually retaining the ownership over your work. So this is a basic example of IP or copyright. Only human can actually possess an intellectual property. So even if there is a case in the United States where a person want to register the selfie of monkey over an animal, but it was certainly rejected. So bear in mind that only intellectual property can be registered only to human. Even artificial human is not considered as human. only human-natured author is considered as applicants to the intellectual property works. So this is basically a component of intellectual property. As you see, sometimes most of the people confuse between these three components. When they come to MIPO, for instance, they want to register, they ask officers of MIPO that I want to patent my book. Some other person come to MIPO that they're asking that I want to trademark my innovation. So these terms are very confusing. We don't actually patent a book. We copyright a book because it is a book per se. When we want to trademark something, we are looking into the different parts of protecting brands and not protecting innovation. So this classification of rights, classification of components must be understood before we are moving in registering our work. We have an industrial property. The other part of the IP component, we have a copyright. We also have a common law. And this type of intellectual property can be owned, sold, charged, mortgaged, inherited. It is like any other part of properties, and it has value. The difference is that in property, there is a tangible and intangible property. Intangible referring to something movable, where tangible is a real property like house, where it is immovable. That's the difference between these two underlying idea of properties. Okay, so this is the components of intellectual property. Okay, you would see that in industrial property, we have a patents, trademark, industrial design, geographical indication, integrated circuit layout design. I will not discuss this type of intellectual property, but more or less I will focus more on the corporate part of the intellectual property. We have also the common law principle to protect some works which are not being protected under the existing legislation in Malaysia. For instance, the trade secret, unfair competition, misappropriation doctrine, and passing off. We will see what is the differences between these three components. Okay, this is an example of the product. Okay, you would see one bottle of Coca-Cola consists of different parts of intellectual property. We have a patented dairy composition with high potential sweeteners of the Coca-Cola strain. The trade secret is regarding the recipes of the drink. Trademark mostly referred to the brands of Coca-Cola itself. Copyright is a commercial advertisement, and industrial design would refer to the bottle and merchandise. In our new act, even you can actually trademark your design of the bottle. Trademark Act 2019. There is the new elements being passed in March 2022. Another example of underlying intellectual property in a phone, let's say, for example, a trademark is an Apple logo. Okay, trade secret is referring to the method for technology or software development. So patents would be referring to the internal parts of technology when first invented could be subject to a patent. It is like a sliding technology. Yeah. So patent is something about solving a problem. Industrial design referring to the shape of good, and content or apps itself can be copyrighted. So we would see the difference in the industrial property copyright. So as you would see, patent is actually an invention, means an idea of an inventor which permit the practice to the solution to a specific problem. So I will just fastening on this part. So duration of patent is 20 years, maximum 20 years. Okay, so patent is actually, you are using it to create an innovation that's solving the problem of technology. I will just give you an example. A person draw a Mona Lisa picture. So they have a drawing of Mona Lisa picture, and they come to MIPO, and then they want to actually register for intellectual property. He doesn't know what types of intellectual property they wish to registering for. So they come to MIPO and go to the corporate division. Hello, MIPO. I want to register this drawing. I want to, as a copyright IP, as a copyright protection. So they can do so. But, and then let's say some other times, B comes to MIPO and then bring a drawing and ask officers of MIPO, I want to patent this drawing. So B were not permitted to patent a drawing because drawing is not protected under patent. It is only copyright. Drawing is only copyrightable unless that drawing can solve a technological problem. Let's say, for example, a person infected with flu or fever or COVID, coronavirus. So when they look at the drawing, instantly their fever would be gone. It's already recovered. So that drawing might have some underlying solution to recover a person, to make them recovered from fever, for example. Then that drawing may be patented. So that's the difference between copyright and patent. So patent is solving a problem. If that innovation doesn't solve a technological problem, then you can copyright your work. Okay. And I will skip this criteria of patent. So I will just move on to the trademark. Trademark is actually, before we have actually two different acts in MIPO. We have a Trademark Act 1976 and a new Trademark Act 2019. So Trademark Act 1976, we only recognize a traditional mark. If you want to protect a trademark, we only protect a word, name, signature, numeral, device, brand, heading, label, and ticket. But now you can actually register your non-traditional mark. You can register the color of your product mark. Let's say, for example, Cadbury color purple. So Cadbury registered their colored purple mark to protect their specific colors of purple. Okay, and also non-visible mark, like the smell of the Play-Doh. Okay, you can actually register the smell of the Play-Doh, but you can actually explain the smell of Play-Doh, like what has been written on the slide, which is the combination of sweet, slightly musky, vanilla-like fragrance with slight overtones of cherry, and so on. Okay. This is a trademark. The protection of trademark is 10 years and may be renewed for another 10 years. Okay, this is an example of a collective mark and certification mark. This is an industrial design. Okay, industrial design is basically features of shape, configuration, patterns, ornament applied to an article by an industrial process. Okay, the maximum protection is 25 years and extendable for 4 consecutive terms for maximum of 25 years. This is a very clear right. So industrial design are mainly referred to a product. If you register the packaging of the product, the 3D and 2D version of the packaging of the product, you can register it with MIPO. And then we have a geographical indication, which talks about the indication which identifies any good as originating in the country. Okay, we have the well-known manga harum manis and perlis, and we have a Sarawak paper where the goods only can be identified from the source of origin in that specific provinces of or states in Malaysia. And last elements, components of intellectual property, which is called the integrated design of layout circuits, which is mostly referred to the machinery or the integrated circuit embedded in the machines. And we will now move on to copyright. So I think if you have any questions available for me, so I'll be gladly to answer on your behalf, or otherwise I will just move on our next slides. Okay, I think so far so good, isn't it? If you have any questions.
Yes,
Yeah,
Cik Shafiq.
okay. So I'm taking about 20 minutes to explain what is IP. So I do hope when we enter into a copyright, we can actually make the differences between industrial property and copyright. Okay. And in Malaysia, our Copyright Act was gazetted in received a royal action and gazetted in 1st December 1987. Okay. We actually amended 9 times of our Copyright Act. Okay. Sorry, this is slide in Malay. I will give English part of this slide later to the moderator. We amended our Copyright Act in 1990, 1996, 1997, 2000, 2002, 2003, 2012, 2020, and 2022. So it is so much amendment made in a series of years, considering copyright is moving from the traditional to the digital parts. So that's why our topic of our webinar is very relevant, that we want to actually prevent infringement or piracy that pose a significant challenge to the right holders' exclusive right, mainly to the researchers and authors. And in copyright, we actually have 6 categories of work. So as you would see, wait a moment. Okay, we have a literary work, we have a musical work, we have an artistic work, we have a sound recording work, film, broadcast, and derivative work. I do believe that most of you has made a significant registration to your literary work, musical work, artistic, and sound recording. So most of the International Islamic University work comes directly from a literary work and also some sound recording and music. Okay. And the third part of IP component, we have a common law. So in common law, we have a trade secret, which formula, which or generally known as information, which cannot act as an economic advantage over the competitors. And we have a third law of deceit of passing off, where all the unregistered trademark, which is not being filed to MIPO, they're still getting the protection under the passing of common law principle, unfair competition, and misappropriation doctrine. So before we are moving towards the focusing on what is copyright, we should see that the values of copyright in our daily life. Okay. Okay. So for industrial property, in order to get in exclusive rights over your creation, you must register it with my IPO. So if you want your works to be protected, you will get at least a certificate issued by my IPO. But for copyright, actually, you don't have to register it with MIPO. When you create your work is automatically protected in copyright. But it would be advisable if you could file your copyright registration to MIPO to get at least a proof of ownership over your work. So copyright values in our daily life. So why we need to respect copyright? So in terms of copyright protection, when a person creates a work, they actually invest a significant elements or significant time, effort, material, judgment, and skill to create the work. So this is the example of the kids who actually collect all the copyright collected. We call it a Hot Wheel card, where he spent a significant time over his years to collect all Hot Wheel card in order to get a protection over their work. So as you would see that the purpose of copyright itself to encourage progress, to reward creative effort and promote societal knowledge. Like what has been mentioned before, copyright is actually a bunch of exclusive rights. If you don't have a copyright protection or you don't actually register it with MyPo, there is no progress in technology, and the authors of the work would not rewarded for their creative efforts. This is an example of the importance of copyright. This is a Hot Wheels 1969 pitch rear loading Volkswagen pitch bomb. Okay. This is the famous one. It was created only 2 to be exact in the world, and the price of each piece is amounting to $100,000. It is a copyrightable work. It is valued at $100,000. So just thinking, was very expensive. Why? Because the creator of that Hot Wheel car investing significant amount of time in creating these 2 works, which is valued more than 100,000. This is an example of the Happy Birthday song, song by the Hill Sister. Still, it is a copyrightable before. Warner and Chappell was required to create a 14 million pool for repayment royalties he had collected since 1949. So as you would see, before it would expire or before it was come into the public domain, you would have to pay in the event that you are singing the Happy Birthday song in the commercial premises. So it is a copyrightable song. So it is copyrightable. This is an example of the Beatles, the Beatles lyric, okay, amounting to $1.25. This is an example of drawing. 300 million is a very huge of amount, and this is a Mona Lisa drawing, which is 782 millions. This is the first action comic books, and this is another Amazing Fantasy Spider-Man book, which is valued at 1.1 million. Example of the film works, the first Star Wars Adventures and the next Star Wars Adventures. Okay. So why I've been emphatically talking about this kind of copyrighted works? So it is important because at the moment you create your work, you can value your work by yourself. You can actually value any amount that suits your copyrighted work at your wishes. So we are moving on to the basic concept of copyright. Okay, like I've been mentioned before, copyright is actually an exclusive right given to the right holders for a certain period of time. It sometimes refers to the right of control, and the protection is based on Copyright Act 1987. Okay. When the government have given you a copyright, you have secured in your copyrighted work, so you can actually make various dealings over your copyright. So the example of dealing that being permitted over your works is as follows. You can make a reproduction of your work in any material or form, the communication to the public, the performance, showing or playing to the public, the distribution of copies to the public by sale or other transfer of ownership, and the commercial rental to the public. I will explain this one by one so that you have an idea what is exclusive rights given to you after you're securing your work and so on. So the reproduction in any material form. When you create a drawing, let's say for example, a Petronas Twin Tower, somebody takes your drawing and duplicate it or photocopying or embedded it in a shirt, you can actually prohibit that situation because it has infringed your exclusive right over your work. So reproduction is actually making one or more copies of work in any form, includes 2D or 3D. So when we see copy, copy is also referring to reproduction of work, and there must be a material form. So in any event that somebody infringe your right by taking your drawing and put it into other merchandise, you can actually prohibit that because the government has given you a monopolistic right of right to control. The communication to the public. As the holder of the copyrighted work, as an author of the work, when you create a film or sound recording, for instance, and your song has been communicated to the public and use it for commercial purpose, you can actually stop the transmission of the work to the public. So it is unauthorized to actually communicate your work to the public without your consent or permission at the first place, even it is for non-commercial nature. So you have the right to actually stop the action of communication to public over your work to the public. So when your work has been performed by through a busking or playing, showing to the public in the public events or space, you can, the law, the Copyright Act 1987, also give you right to authorize or prohibit such act within your control. So playing, for example, is playing a sound recording, showing, exhibiting your work, and performance, for example, the delivery of the work such as reading, reciting, singing, performing your musical work. So these are fall under the ambit of your exclusive right. So another rights that you can actually control is the distribution of copies to the public by sale or other transfer of ownership over your work. So for example, the act of distribution is sharing something out of number of recipient by sale, rental, lease of lending. And lastly, you would also have the powers given to you to actually control the commercial rental to the public over your work. When somebody are taking your work and do make a commercial rental in a video or bookshop, you can actually prohibit that or request them to actually pay a significant royalty to you over the usage of your copyrighted work. So for copyright requirements, you would see that before you are filing for your copyright, some other persons, some applicants doesn't aware because their copyright was actually revolving around whether my copyright is original or not is subjective in nature. So you must have a knowledge that when you're registering for a copyright, your work must be original. Your work has been fixed in a material form or published in Malaysia or any Berne Convention country. So we are taking this matter one by one. So we are looking to the originality part of the copyrighted work. You must remember, when you create a work, it must be original. Original in the sense that you don't copy other work and incorporated that work as your work or credit other person as your work. That is totally not original. Originality comes when you actually invest the sufficient effort in skill, effort, and judgment where you are not copying others' work and it is new to you. It does not to be a novelty. It does not to be a novel. You must actually have a significant investment where your effort, skill, and judgment are exercised over your work. That's the first copyright requirement, which is originality. And secondly, your work must be fixed into a material form. A mere idea revolving in your head are not protected as intellectual property. You must actually put it into a material form, make it into a writing. If you have a song, you record it in a song recording and reduce it into any other material form that can attract copyright protection. And thirdly, your work must be published. It doesn't make sense if your work is not published because, or otherwise, people would not know the existence of your work. So Berne Convention is actually a convention which is put a standard of renewal protection to each country in the world that promise to give their local corporate protection to the citizens of all countries that sign the Bern Convention. Malaysia is a party to the Bern Convention. When Malaysia signed a Bern Convention treaty, so Malaysia is actually recognizing the importance of corporate protection in Malaysia. If you register a corporate in Malaysia, you want to protect it in Singapore, you just go to Singapore, bring a statutory declaration, get it notarized public at the nearest embassy, and that's it. Your work will be completely protected in Singapore, for instance.
Cik Shafiq.
Yep.
Okay. With the Bern Convention, so basically, when a requester file a copyright at MyIPO, they will get the notification and they will get the certificates from MyIPO, right? So they can bring the certificates or the notification to any country that have signed with the Bern Convention. And then that means the copyright is protected by that specific country, isn't it?
Yeah, but in Malaysia, before you are going to protect your work in other country, you must first protect it in Malaysia first. So the way your work can be protected in Malaysia is you make a statutory declaration or file it with MyIPO. That's it.
Oh yeah, for the participants, if you have, for the Zoom participants, if you have any questions during Cik Shafiq presentations, you can just unmute yourself and just ask Cik Shafiq, yeah? Right, thank you. Okay, over to you, Cik Shafiq.
Okay, thank you very much. We will continue with the ideas and expression. So this is the example when you have an original idea, and then you express the original idea, then your work is automatically protected. So the concept of original idea and expression, for instance, has been incorporated into the Section 7 of the Copyright Act 1997, where the originality requirement and fixation requirement has been embedded in Copyright Act 1987. So before you are registering your copyrighted work, make sure your work is original and express it into a material form. So I think I have a question from Anis Azia where, bolehkah hak cipta dipindah semasa masih dalam pelindungan? So I will just answer this question in the next slide because I have the answers in the next slide. But the preliminary answer is yes. Okay. This is a method of proving ownership, like I have mentioned before. You can make an affidavit. It is a court declaration made in front of commissioners for oath. You have the statutory declaration. And also we have a certificate of notification where you file it with MyIPO. With these three methods of proving ownership, you can actually bring that proof of ownership over countries in the world, get it protected in their respective countries, and get it notarized public in the embassy of that country. Okay, what things can be copyrighted? Things that can't be copyrighted, for example, an idea, a procedure, a method of operation, mathematical concept. For example, 1 + 1 = 2, facts and discovery. So these things cannot be protected under the copyright legislation. So if you see my slide, the chip bird idea or facts, for example, cannot be attracted, cannot attract copyright protection. This is an example of duration of copyright protection in the world. Malaysia, we retain the 50 years copyright protection in the world. As you would see, United States, for example, the duration of copyright protection is 100 years. Singapore is 70 years. Some other Latin American countries, 70 years. So why there is a differences of the duration of copyright protection around the world? So the things to consider. Malaysia, we are acceding to the Berne Convention. Since Berne Convention is underlie a minimum protection of 15 years, so Malaysia has incorporated a 50 years duration of copyright protection. Otherwise, compared to the United States, where most of the copyrighted works are being produced there, so they need to protect their authors, producers, right holders in the US by giving them a long monopolistic nature of duration of copyrighted work in the US. Malaysia, for instance, why we have a 50 years duration of protection, perhaps on the basis of Malaysia, we are consumers of the entertainment goods. Compared to the Korea, their duration of copyright protection is 70 years because they are producer of K-pop entertainment goods to be exported to the Malaysia, for instance. So in order to increase the duration of copyright protection, we actually should become producing nations of entertainment work, because most of the GDP of Malaysia, for instance, we are heavily rely on the palm oils and agriculture community as compared to Korea, where they rely heavily on entertainment industry as a source to export their goods, and also the United States. This is a classification of copyright. You would see that copyright, we have three distinct features of copyright, which is we have a work as a result of creation, which is a literary work, artistic work, and musical work. We have also a work as a result of fiction, which is film, recording, broadcast, and performance right. For example, a person creates a song lyrics. They can register that lyric under their types of literary work. And also, a person creates a musical notes. They can register their work as a musical works. When a lyric and musical notes are combined, where they are calling a performer to perform a song or sing a song, they would enter into a studio. Okay? They would create a new work as a result of fixation ataupun penggabungan, and they will create a song recording. So we call it the work a fixation work. And apart from that, we have a derivative work, a work that comes as a result of original work. For example, a translation, adaptation, arrangement, and so on. So when you translate an original work from Bahasa Melayu to English, your work will be considered a derivative work because it's been adapted to a new work. The duration is still the same. This is an example on how to calculate a copyright duration. So for a researcher, most of you are writing a journal or writing a research, for example, then your work is a literary work. How to calculate the copyright duration? It is very easy. For individual, the copyright will subsist during the life of the author plus 50 years after his death. Let's say, for example, A resumed death on today is 2nd December 2022. So the calculation would start the next calendar year. So it would not start the date of his death. The duration would start probably on the next year, which is on 1st January 2023 plus 15 years, which the duration will be fall into the public domain on 1st January 2073. For a joint authorship work, you must wait until your partner dies. So it will call a life surviving authors. So from that period of time, it will be calculated next year's plus 50 years after his death. So these are the three categories of work that will be calculated based on the life of surviving author. For a published work, the duration would start after your work has been first published. Let's say, for example, a company, a producing company house, they created a published work. Okay. They created a published work, and the work has been published today on 1st December 2022. So if it starts the next calendar year on 1st January 2023, and will be expired on 1st January 2073. It's very easy. You can just referring to this slide. So we are moving to the authors and owners, right? Okay. So what do corporate holders have over their rights? Basically, you have three rights, underlying rights when you register for copyright. You have an economic rights, you have a moral rights, and you have a legal rights. For economic rights, it is a right to actually getting a revenue or financial reward as a use of your work. So when a person use your work, you should receive a financial reward in the royalty terms. So economic rights actually allow authors and creators to take certain action to preserve and protect their link with their work. So in simple terms, is that economic rights is attributable money receiving reward right, where when you deal with A, B, C, and D, so A, B, C, and D will give you some amount of royalty because they want to use your work for commercial purpose. The next right is moral right. Okay? Moral right allows authors and creators to take certain actions to preserve and protect their link with their work. And then we have a two classification of moral right, which is a paternity right. This is a very clear-cut example. Attributable to your parents. My name is, let's say, for example, Muhammad Shafiq bin Abdul Latif. So my paternity would belong to my father. It is the same with the copyrighted works, where your name will be perpetually have on the over your work. So you would see this is Harry Potter. Okay, it is supposed to be right by J.K. Rowling, but other person remove the J.K. Rowling name and put their name over the work. So there is a clear infringement of moral right because it is changed to Ahmad Albab, for instance. So you have the right to actually prevent that your name from being removed from the work. And then we have an integrity right. When you create your work, you have been given a power to actually restrict any other person to destroy or make a derogatory statement over your work. We have a clear example on this case. And the third right that the corporate holders have is the right and sue and enforce your exclusive rights, what has been mentioned before. So as an author of the copyright owner, you have 5 exclusive rights. You can enforce your right based on the infringement of case over your rights and any authorized use of your copyrighted works. This is an example of the case law where mostly it refers to the infringement of integrity rights under the moral right. In this case, there was a sculpture made in front of the DBKL office, which is called a Puncak Purnama. Okay, I think you can Google this case in the internet. Okay, in 1986, and then the DBKL make a significant changes to that sculpture, which put fences around the Puncak Purnama and make a deliberate painting to actually make it new to the public of the existing work. And I think in 2005, that sculpture had been removed and replaced it with a permanent others building. So what happened was, Syed Jamal sued Datuk Bandar Kuala Lumpur and claims for damages done in breach of the integrity rights or moral right over their work. And the court agreed with the Syed Jamal and awarded 715,000 aggravated damages to be paid to the Syed Ahmad bin Jamal because causing injury to the plaintiff feelings, dignity, and reputation. So it is just to highlight that when you create a journal, for instance, So mutilation of your journal or destroying or changing a significant amount of phrases in your journal would amount to the breach of integrity right, and you can sue any person who actually make changes over your work. So then we are moving to discussing the category of performance in copyright work. Okay, I will only discuss the three works here, which is the literary work, musical work, and artistic work. So for the literary work, we have many types of players in the work. We have the author. Before the creation of the book, for instance, we have a first author who actually created a manuscript. When that manuscript has been given to the publisher, we have to adhere some set of terms of rights and so on. And there is a process of editorial, visual creators, content development before it goes into making a novel, for example. And then you can actually make a sell and purchase of your work and license over your work. So here, each party, an author, editorial, visual creators, producers, or publishing house have their rights over to the extent what has been contributed over their work. You would see that author, they may register their manuscript, and visual creator, they may register their visual appearance over that book, content development to the extent of derivating work or making the content organized and so on. The publisher, maybe they retain their publishing rights over their creation of the novel or manuscript. So it is just not necessary that one person may own one literary work of book. So they may be a various layers can actually register their extent of contribution over the IP works. And then we have an artistic work here, where artists can make a drawings, can make a wood carving. So this is a type of players. Okay, for the artistic and literary work, we have a computer software. You can actually register all these things where we call a source code and so on. And a musical composition, where composer register their musical notes, lyricist register the lyric, and so on. So I will just skip to the most important part of the derivative work. Okay, this is an example of derivative work. You have an original work. Okay, you create a book, and let's say a new party want to translate a book into an English version of it. They can do so, but that work is a derivative work. It's considered as new work. A book being transformed into a film. That film is a new work because it derived from original work. Compilation, when a book has been compiled into a compilation, let's say for example, the Malaysian Law Journal, the compilation of journal, the external compilation is also can attract copyright protection and may register to MyPo. KLCC picture, you put it into a collection of series of view from KLCC and you want to register it with MyPo, you can do so. This is a collection of work.
Cik Shafiq?
Yes.
Right now, currently researchers also put writings in ebook. Okay, so the researchers write an ebook. Okay, and then the researchers would like to copyright the ebook. Is it permissible?
Yeah, is it permissible? Yeah. Ebook is considered they have the same copyright level of protection like physical books. So the only thing is that the medium of protection is in ebook, which is a soft copy. They are still a literary work. You can register your ebook also.
Right.
Okay. So we're moving to the ownership and dealing and copyright. So I'll be just answering the question in the chat box. Bolehkah hak cipta dipindah milik semasa dalam perlindungan? Yes, it can be transferred to a new person while the duration is subsist. So we are moving on to the authorship. This is a very critical and crucial issue where we receive numerous complaints regarding who is the author, who is the owner, and the case end up in the court. So before we are not moving to far extent to the court, you must understand what is the authorship and ownership. So in Copyright Act, author is actually the first owner. So when a person creates a work, he is the first owner of that work. That author can be a joint author as long as the work has been produced by collaborative effort. The contribution must not be distinct or separate from the other, and contribution by each author must be in the form of requisite skill and labor necessary for the creation of the work. When a person, for example, they create a journal, and for sure there must be a co-author, third author, fourth author, and so on. So each author must know the extent of contribution in terms of registration of their work. If you don't specify the extent of contribution, the extent of ownership over the work, we will treat all authors sharing the same or possess the joint authorship, equal ownership over the work. It is not like macam tanah lah kan. When there is a existing 3-person name on the grant, issuance of title, the ownership of the land, it depends on the percentage of the land. So in IP, if you don't specify that thing, we treat all produced work by collaborative joint author as the same equal ownership. Example, when an author is a songwriter, style IP writes a new owner, so then the author is no longer an owner. The author only retains a moral right. Then the new owners retain an economic right to commercial the work. I've been explained before the difference between the economic rights, moral rights, and also the legal rights. So since in this case, when the author has actually sell the IP rights to a new author, they only retain the moral rights. Moral rights in terms of the new owner cannot remove their name over the work. This is an example of the case where there is involving issues where you would see in the news where Wardina sues Maiden regarding the use of his drawing in the advertisement in the Maiden lorry. And the images has actually been sold to Maiden, where Maiden has exclusive right to retain over that images. Okay. And then later on, the case was agreed to end a dispute where the Maiden relieved the suits not to have a court settlement suit where the Maiden would not use the images anymore. Okay, so the initial moment is that when you actually sold your IP rights to some other person, you can actually claim that monetary ownership over your work because you don't actually own it anymore. Even you are the author of that work. Okay. This is the presumption of copyright ownership.
Shafiq.
Yep.
There's a question about the Wadina just now. Okay, just let's say a person noticed or the copyright has been infringed. So where should he go to file the report? Whether to MyIPO or whether to hire a lawyer? So where should the person go?
Okay. If I may, I will answer your question at the next slide. I think I've been provided the methods of filing a complaint. So here I will just highlight. Yep. Here I will just highlighting on infringement itself, since our topic was covering around the stop piracy. Okay. So in terms of ownership, you can actually, your work, the types of ownership when an employee is given a task to create a work in the course of his employment, and he's been paid to do that, then that work belongs to the employer, because that employee is getting a sum of money over, even though he is the author of that work, because he creating the work during his course of employment, then his work belongs to the employer. The ownership of the work owned by the buyer or one who commissions such work will be transferred to the buyer. This is in the case of contract of employment. For the commission work, when a person hires a photographer, for instance, they paid 1,000 some amount of money, then the collection of the photograph taken in the wedding ceremony, for example, will be transferred to a new owner. The author only retains an authorship over their work. Okay. Even this can be done during the subsistence of the copyright ownership. And this is the presumption of copyright owners. And we are moving to the dealings in copyright. When you want to actually transfer your copyright material to other person, you can do so by assigning your copyright in part or full assignment to the copyright ownership. This has been done by many businesses over there, where, for example, J.K. Rowling has diversified his business by assign some of the license right to McDonald's to create toys, Harry Potter toys in the McDonald's, for example. And she also assigned his right to Warner Brothers to make a Harry Potter film. So it can be assigned or pindah milik. It can be perpetual or temporary, but it must be in writing. Your copyrighted work can also be licensed to other persons. Okay, like Astro getting a exclusive license to broadcast World Cup that we are currently watching right now, right? So Astro is only the broadcasters holding an exclusive license from the FIFA to actually highlighting, broadcast all the matches in Malaysia. And copyright also can be testamentary disposed and put it under a Creative Commons license, limited use license, and exclusive license. I will skip this part. I will move on to the most important part, okay, regarding the limitations and exceptions in copyright. So as you would see in copyright, we have a specific parts on fair dealings, exceptions and limitation, and fair practice. You must understand that these are three elements that you can actually utilize whether your usage of work requires permission or not. Okay. For the fair dealings, if you want to make a research, private study, criticism, review, or reporting news of current event, you don't actually require a copyright owner's permission. It is the same when you write a journal, but you have to acknowledge your authorship in your journal, okay? And no acknowledgement is required is reporting of news. That's why if you watch a news, they don't say a specific line of this picture comes from blah, 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 because no acknowledgement is required. Unless if you make a journal, you must have a sufficient acknowledgement where it is wrote by, for example, Abu 2011, what is the work, and so on, because it is purportedly doing for research and private study. And then we have exceptions and limitation, where you don't require permission from the copyright owners for making a parody, pastiche of caricature, inclusion in a film or a broadcast of any artistic work. Okay, when you take a photo of KLCC, you doesn't require a permission from the owner of the building of KLCC because that work is permanently situated in a place. It is been permitted. You can take a picture for a permanently public building to include it into the copyright material. And incidental inclusion of that work, when you shoot a movie and then sometimes a McDonald's logo comes in, Samsung phone, the actors use a Samsung phone during the shooting of that film, then it is permitted. You don't require a copyright owner permission. For teaching purposes, illustration for teaching, you can include any copyrighted work during your teaching. That what has been mentioned, what I've been doing just now. And you want to include a copyrighted work for purpose of examination. You want to include artistic work, phrases, line from journals, as long as the purpose of candidates answering the questions and so on. Reproduction made by educational institutions, private and domestic use. Okay, for print disability person, the Marrakesh Treaty. So the Marrakesh Treaty is very important. So the Marrakesh Treaty highlighted some of the important elements of giving rights to the print disabled person. Malaysia, we are joining Marrakesh Treaty back in 30th March 2022, where now the print disability person doesn't require absolute permission to make a copies of the work translated into accessible format copies. Previously, the law has been unclear on their rights, but when Malaysia incorporates some of the elements of the Marrakesh Treaty, the law clearly stated that print disabled person doesn't require a permission when they want to create a braille works, or we call it accessible format work over their personal use and not for commercial use. Another exception and limitation is that they can public and reading or recite in public for non-commercial purpose, reproduction under direction and broadcasting service, for non-profit making club, purpose for judicial proceeding, quotation of published work, reproduction by press, commercial rental, making transient or incidental copies. So this is an example of exception and limitation permitted where a user or consumer doesn't require a permission or pay some amount of royalty when they want to use a specific work. And this is a fair practice or amalan wajar. Okay, I think the library must know this provision where they are empowered to make any use of their work in their libraries being gazetted under the law, where as long as no profit derived therefrom and no admission fee is charged. So the library, for instance, which is being gazetted under a specific regulation, can make any use of that work in the library compound to digitize, preserve, put it in specific copies and so on, as long as it is not profitable in nature and no admission fee is charged for doing so. Okay, then we are moving to the interesting part of our webinar, where it is a copyright infringement. So I think you have an idea what is copyright, what copyrights are protecting, what is the basics of copyright, what is the copyright requirement, who are the players in copyright, and also what do users, what can users do or users can do in lieu of the other person works. So when you understand this kind of things, you would have to look the copyright infringement part. Copyright is infringement that actually when a person use others person work without consent, and they actually has infringed an exclusive rights given under the law. So if you would see, these are exclusive rights of the authors or owners, or you are being given to you when you register for your copyright or filing of copyright in MyPo. But other person take advantage of this exclusive right and infringe this right. The act of infringement itself is sometimes called a piracy because it involves using your work without consent. We would see what kinds of infringement here. So under the law, section 36, copyright is infringed by any person and who does, for example, sell, trade for hire, by way of trade, offer, and export. And then we have an indirect infringement, where copyright is infringed by other person who does or cause any person to do so. So when a person A use someone else's work without consent and post it in to gain a commercial advantage, okay, then that person has infringed exclusive rights of the right holders or copyright owners. Another person is that he take that work or he posted that work to the social media and create a link. So that person might constitute, might do an indirect infringement because he caused any person to, any other person to do. Okay, when he posts illegal links to website, then that link directs a user to an illegal content. It's assumed to do an indirect infringement because it helps A who does that infringement. Okay. More or less it's like an abetting lah kan, macam menolong orang lain untuk melakukan sesuatu kesalahan. Okay. Then it will come to cetak rompak or plagiat. Okay. So piracy is actually you copy someone else's work and sell it without permission. But for plagiarism, you use someone else's work and credit it to yourself. So more or less, piracy and plagiat are the same thing. But plagiarism is much more heavier penalty because not only you use someone else's work without consent, you credit your work under your name. So it can mostly seen in the thesis or journal where you doesn't actually acknowledge the original author, then you will constitute an act of plagiarism. Okay. And this is an example of copywriting. Okay, copywriting is basically the art of science writing to pitch your product. You make a product where the customer will be convinced on your copywriting and buy the underlying product. So there was a case in Facebook where posted in Nabila Jalil. You can read it by yourself, but in summary, that girl attended an interview with the tea life company. When the tea life company saw when that girl gave a tagline, test or tagline like Yumi, yogurt and fruit slushies, and company take note of that tagline, and after a few weeks, even that girl, not hired as intern, but her tagline was posted in one of the slushies drink for tea life. So he feel upset regarding the theft of copywriting. At the end, it was settled amicably, where she told that the tagline was belong to her, and then the Tea Life Asia cannot use that tagline of Yomi Slushy, and wished to apologize and pay some amount of compensation. So even copywriting is also copyrightable as long as you acknowledge it under yourself as a copyright material. So there is some case study here regarding the copyright infringement. Okay. We have two case law of the sound recording. Sorry. Okay, I just moved to this case law. Siti Khadijah Apparel against Irni Textile Manufacturing, where Siti Khadijah has sued Irni for copying a substantial amount of design or drawing to make a telecom. Okay, Siti Khadijah owned a telecom, classic PKSA 2.0, where Irni has introduced a telecom Nur Alisha. So what is being alleged, or what is the disputes goes around, is that Khadijah sued Irni for the reproduction of the telecom first, whether you have to actually look at the criteria, copyright requirement before you are suing someone. Okay, when Siti Khadijah claims that the Irni has reproduced the telecom, the category works of copyright protected is artistic work, and the infringement mostly occurred on the headgear, size and position of the telecom, and material used to support users' change, including the solving of the rubber line. So at the end, Irni lost the case and have to pay a significant amount of money as a compensation to Siti Khadijah. We have another case of scope production against alias Idris. So in this case, the alias Idris is the one who wrote the novel entitled Aku Bosia. So he claims that a movie created by Scope Production has infringed his right by copying substantial amount of storyline, plots, and so on. So in High Court, the plaintiff, or alias Idris, the owner of the novel, lost the case because there was no elements of copying, because the existing storyline of Aku Bosia it is more or less like a social illness existed at the time, was already exist. So even when you make a novel to that to give a public impression that the social illness already exists during that time, that social illness produced by the Scope Production was not infringe your novel, the court says. And at the Court of Appeal, the plaintiff won back because there was a significant copying in terms of the numbers of actors. The specific storyline of Mak Rempit exists in that book. But the case was overturned again at the federal court, where the Ilyas Idris lost against, because the court has clearly decided that the social illness of Mak Rempit, Mina Rempit exists at that time was a generic. So everyone can make a storyline, even if you don't have to create that book. So this is an example of generic ideas where it is not protected under the Act. So this is regarding with the telecom just now. Okay, when a woman was arrested in fake Siti Khadijah telecom says, okay, and this is an example of video of Munafik 2 in social media being copied. This is regarding the Android box. I don't have a case regarding the literary work, because mostly I think personally in terms of text with regard to the journal writing, research writing, and so on, rarely happen in Malaysia. Okay, there is a case, but the case was not unreported, and also most of the case have been settled amicably. So this is the case of Android box, where now when you put IPTV to the Android box content, you assumed to possess an infringing work, and you'll be subjected to a criminal offenses. Yeah, this is an international case where the Ed Sheeran is sued on photograph copyright infringement claim regarding his musical notes. for song of photograph. Okay.
Cik Shafiq?
Yep.
Oh, we have questions from YouTube participant from Nash. Assalamualaikum, Cik Shafiq. Is there any difference between copyright law 1987 with Creative Commons license?
Okay. Okay. So I will just skip back to the Creative Commons license. Okay. Here. Okay. Creative Commons license is the license that the owner of that copyrighted work put into their work. So what is the license? The license would say more or less like this. The work can be used by anyone in the world. Acknowledgement, however, acknowledgement is required. Some Creative Commons license would further indicates that you can actually use that work for commercial purpose. Okay. Creative Commons license mostly embedded in a coding, okay, or a digital license. For example, macam when you create a game app, when you create a temple run ataupun running games yang macam orang lari-lari itu kan, there is a Creative Commons license software yang benchmarking free software where anyone can use and then just upgrade a character on that apps. So that's a Creative Commons license, and then you can sell that apps, that Creative Commons license. Another Creative Commons license embedded to a journal where you can use a substantial amount of a journal writing authored by other person, and you can make significant changes over their work because the permission has been given to reverse engineering or use anything, including changing most part of the elements of that journal and use it for your own commercial advantage. That's a Creative Commons license. Creative Commons license is not embedded under the Copyright Act 1987 because the current Copyright Act 1987 only entailing what copyright owners can do. Since copyright owner have an exclusive right, for example, to control over their work, they can also give part of their work to the assignment, where they give a partial ownership to any licensee subscribing over their work in the internet. So that's it. So Creative Commons license is a creative license where you can use the work, but acknowledgement is required, but you can use for commercial purposes. That's the difference between Creative Commons license and Copyright Act 1987. I hope that answers your questions. Nash, isn't it? Nash, yeah. Okay. So I will taking just 10 minutes before you're moving to Q&A session because I will moving fast on the corporate penalties and corporate action. So corporate penalties in a nutshell. So this is just in a nutshell. If you infringe any of offenses as stated under the exclusive rights of the owner, let's say for example previously owners have the 5 exclusive rights has been mentioned before. Okay, this is the owner's exclusive right. Exclusive right, okay. Okay, this is the owner's corporate owner's exclusive right. Let's say you infringe one of the rights has been enshrined under the Copyright Act. You make photocopying a book or journal. So each piece of photocopying you copied would be penalized. One copy is 1,000, for example. So if you're making 50 copies, 50 times 2, so you will pay more than 100,000. That 2,000 is ranging and maximum for 20,000. Like Siti Khadijah case. So I think one piece has been created by Ariani is decided at 4,000. So 4,000, they are making 1,000 copies. They have to pay nearly 500,000 for that. So that's only the photocopying part of that work. If you distribute, if you possess, if you import into Malaysia or manufactures, then it will be much more. So that's the penalties. Just remember, each copies in contrivance copying that you made is around 2,000 or 20,000. There is a bundle amounts of money, which is we want to penalize the one who actually infringe other person copyright act. Another thing is that corporate owners is also given the civil actions to claim what has been due to him, where he can ask the court for an injunction to stop the copyrighted works from being infringed further. He can ask for damages, compensation, accounts of profit. Let's say, for example, he should get 100 ringgit for each copies made by any other parties. So he would want to claim the profits made by other person and any other order as the court deems fit. So instead of, apart from the infringers getting criminal penalties, they would also be subjected to a civil action where he would be ordered to stop for any infringing copies that have been made before. So action by corporate owners and relief. So this want to answer the questions where you must actually determine your ownership first before you are taking an action to the Ministry of Domestic Trade. Determine your ownership, whether you are the owner, assignee, licensee, testamentary disposition, or person who have interest in that work. If you don't have an interest over your work, you can actually make a complaint. Okay, you must secure your copyright, get your copyright under your name, regardless you are the owner, assignee, or licensee. Then you can initiate the copyright complaint. And secondly, after you determine your ownership, you must establish your ownership through a method of proving ownership. Affidavit, statutory declaration, or voluntary notification of copyright has been mentioned before. So this is the method of proving ownership. I think I have this one. Yeah, I've shown you before the methods of proving ownership. Yeah, this one. Well, you must establish your ownership through statutory declaration or securing your copyright with my IPO. Okay, yeah, with the certificate of copyright. And then you can commence a civil action. Okay, you claim a civil remedy, like what has been said before. These are the remedy: injunction, damages, account of profit, statutory damages, and any other order the court deems fit. Okay, and commence a criminal action. For commencing a civil action, it is advisable that you are appointing a lawyer. And for criminal action, you can commence a criminal action by filing a complaint to the Enforcement Division of MDCTA, okay, or the Ministry of Domestic Trade lah, KPDN, HCP, Kementerian Perdagangan Dalam Negeri dan Hal Ehwal Pengguna. So boleh pergi kepada bahagian penguatkuasa, Enforcement Division, and prepare the following. Prepare only a valid voluntary notification of copyright. The Enforcement Division of Ministry of Domestic Trade would not accept a statutory declaration. They will only accept a voluntary notification of copyright filed in MICO if you want to commence a criminal action. You should attach together with the evidence of infringement and copies of the work. Okay. I think I would stop here. I think I would not have much time, so I would rather have a question and answer session, if permitted. Or yeah, I handed the baton back to the Ms. Izni.
Great. Okay, for the Zoom participants, if you have any questions, just ask, you may unmute yourself and ask verbally. So far at the YouTube channel, we do not have any questions yet. But I do have questions to Encik Shafiq regarding this slide, okay, copyright owner action over infringement. Okay, we received application, a source code, okay, from the researchers lah. Right. So and then the source code, okay, dah proses semua, okay. Then suddenly, katalah the owner of the source code, they see, oh, okay, the source code is being infringed. So that means the source code is the back end. Okay, if a source code, dia mesti an application. Okay, so let's say the user see the application, ini sama macam source code saya. Okay, so saya dah copyright source code saya. So if an application, where should the user file the complaint? Dekat KPN HEP ke ataupun dekat multimedia, ya MCC ke, macam mana, Cik Shafiq?
Okay, I just want to have a question. That user is who? Is he the owner of that work? Or
yes, the owner. The owner of the source code lah.
Okay. Since he is the owner of the source code, okay, firstly, he must establish his ownership lah. Kalau ikut slide ni kan. He must establish his ownership. Determine types of ownership yang dia ada atas owner tu lah. And secondly, when he already determined his ownership, he must establish the ownership through a method of proving ownership. So it is advisable to establish ownership over my filing lah kepada MIPO lah, kan, dapatkan of a certificate of copyright. And thirdly, we have two types of action lah. Firstly, civil action and criminal action. So basically, untuk civil action, why they are initiating a civil action? Because they want to claim a monetary damages, duit. Dia nak duit lah, hasil infringement tu dia nak claim duit. For criminal action, they want to actually punish that infringer because using the source code without permission. But if you want to site blocking ataupun to prevent piracy sites over the works uploaded ke apa kat internet, you can file a complaint to a multimedia commission authority lah. Saya tak letak dalam ni sebab yang tu bukan kita punya jurisdiction. So kalau you nak ask, for example kan, kalau dia dah upload dia punya illegal content on the website, for example, I take, adalah, other than source code lah, I take film lah kan, film tak kisahlah film apa-apa, they upload a illegal streaming site and they've been deprived lah of their monetary income, they can ask MCMC to site blocking dia punya visit lah. So that's why certain websites you have, this website has been blocked by MCMC kan, because it prevent entry from the users, contoh. But that's out of the scope of MIPO and Enforcement Division of Ministry of Domestic Trade. But you can do so. But still the same thing is that you need a voluntary notification of copyright, evidence of the infringement on copies of the work. Okay.
Thank you, Cik Shafiq. And we also, my experience lah, we receive not a complaint, okay, we receive a report from lecturer. Okay, so the lecturer have published an article. Okay, dah publish, dah siap lah semua. And then suddenly she noticed the same article be published by a different bogus journal. So online. Okay, so what immediate action that she took was she asked the bogus journal to retract the journal, to retract the article lah. So yeah, and the bogus journal retracted the article. But yeah, no further action after that lah. So is that what I'm trying to say is that when an article is published, it is protected by the publisher. Is it right? That Cik Shafi?
Yeah.
DOS 60172664.
Yeah. Saya dengar. Okay. So
DOS.
okay. So the problem is when a person, hello, dengar tak?
Dengar Cik Shafiq.
Okay, sorry. Okay, the problem is when a person creates a journal and other parties repost his journal in illegal sites. I call it an illegal site since it was posted without permission. And also there must be some other publishers who taking that articles without the consent because I don't know, perhaps that article has been published before ke apa ke kan without due acknowledgement. So we have the same case. Firstly, what we ask them to do so is that you send a notice of demand to the one who or the hostess of the website to actually taking down the article. That's the first avenue so that they can take. The second avenue is that instead of asking them to remove the content of journal on their hosting site, they must ensure that the work no resurfacing journals has been reposted before in other websites. You can take your action to the Multimedia Commission Authority (MCMC) untuk block that mirroring sites that reposting the content. Even the links pun can be blocked, and mirroring links can be blocked because kita tak tahu that infringer might have create a new blog and to repost everything. When you're removing one site, they are moving to another site. They're moving to another site. They're looping around in the internet and they're reposting everything. You can't stop that. The problem is you can't stop what internet is doing, but you can only mitigate the risk of sharing the article online by stopping entry of visits to that piracy site by making a complaint to the Multimedia Commission. That's my advice. And if you are thinking of finding the infringer to obtain a monetary damages that should the profits been made when they are posting their article journal, you can't do that because you would not find the culprits online. It will be very hard to track the culprits online. What would you do is that's the best possible avenue by making a complaint to the Multimedia Commission Authority.
Yeah. Thank you, Cik Shafiq. So we have for the Zoom participants, do you have any questions?
Assalamualaikum Cik Shafiq.
Yep, yeah.
Nama saya Anis. Saya ada satu soalan. Sometimes the book published have the copyright by the publisher. Is it allow for the author to apply for the copyright under the copyright law 1987?
Okay, so this is also the common problem faced by the author and the book publisher. You have to read the publishing agreement. You would need to read the publishing agreement when you give whether your publishing agreement are authorizing the publishers to retain some of the publishing right. Okay, generally, most of the publishing agreement states that the author have exclusive right to publish their work and it is their copyright. That's the number one terms in most of the publishing agreement. So secondly, the author would not surrender their copyright to the publisher. Thirdly, publisher only retain the publishing right for a certain period of year. Let's say, for example, 1 year. So that author can only publish with a specific author, a specific publisher. Okay, third. And fourthly, even that author has surrendering a publishing right for 1 year to a publisher, they can still register their work because it is been stated in the publishing agreement. So what is not common is that most of the authors are surrendering all their IP rights to a publisher, and as a result, the publisher pays some amount, for example, 1,000 is very less. So that's the problem, uncommon terms and condition in the publishing agreement. So I think you can look at the publishing agreement first, whether the author has transferred all IP rights to the publisher. If the author has transferred all IP rights to the publisher, then the author would no longer an owner. The owner has been transferred to the publisher. Yeah, that we mentioned before in my previous slide.
Okay, thank you, Cik Shafiq. Yeah, I have another question. Let's say the copyright have many authors lah, joint authors lah. So author A in Malaysia, author B from Indonesia. Okay, let's say, and they file the work in Malaysia. Okay, so then the author B, okay, from Indonesia, is it he or she get the same treatment with the certificates produced by the MAIPO and with the Berne Convention and all that, including the joint authors, even though she is from Indonesian, but she filed the copyright in Malaysia.
Yeah. The second author gets the same treatment as the first author. So regardless, he is the foreign national, he is not a Berne Convention countries, but international framework recognized he is also a joint author. But the problem is, when you want to discussing the extent of ownership over a journal, we treat it as they have equal rights over that journal. Unless, because this is a very rare case, most of the foreign journals, they have the partnership agreement when they're creating a medical or scientific journal, they have a extent as contribution. Let's say, for example, the first owner retain all rights of ownership over that journal. Then the second author only retains the editorial making over that work. So that's a very rare and special case. But most of the journal, I think in Malaysia, they doesn't have that kind of partnership over an agreement where they're stating only second author only retains 7 to 10 pages, for example, and first author only get 1 to 8 pages ownership. No. But some other countries, they have a specific partnership, especially in medical and scientific journal, because it's very valuable to them. But for social sciences journal, I don't think we have like specific kinds of things. But to answer your questions back, they have an equal rights over that journal. Even he is a foreign national.
Okay, thank you, Cik Shafiq. And I also share with the participants the MAIPO public book, okay, copyright in a nutshell. I received this from Mr. Shafiq as well. I put it at the chat box and also the YouTube. So last questions. Do we have any question from the YouTube?
Cik Shafiq,
okay.
Cik Shafiq, ada satu soalan lagi. Tadi Cik Shafiq ada menerangkan tentang hak eksklusif yang diberikan kepada owner tersebut seperti economic right, moral right dan legal right. It is possibilities tak yang owner itself melanggar hak-hak eksklusif yang diberikan kepada mereka? Ke sebenarnya tak pernah berlaku lagi seperti berikutlah?
Okay, this exclusive right, nampak kan saya slide ni kan?
Nampak.
Kan? Okay, this 5 exclusive right given kepada owner is exclusive in nature lah. So they decide on types of rights ataupun types of rights yang dibagi kepada orang ataupun tidak. So if you would say that they would infringe their own right, it is not possible because there is no infringement on their own right because rights have been given to him. So it is not possible for infringement. If he himself exercising their rights, it would only be infringement if other parties want to exercise that right. Unless I think like this is a very rare case. they want to change their moral right. Kan? Contohnya macam buku saya kata tadi ni kan, atas nama dia, J.K. Rowling. But they want to influence their own moral right, they change it to dia punya anak lah. Kan? Ahmad Albab contoh kan. I think it might be possible because the law would not actually permit, even you are the moral rights owner over that work, you change it to someone else, you cannot lah. You cannot change because it is a perpetual in nature.
Right. Okay, thank you, Cik Shafiq. So I think we do not have any more questions from the YouTube and from the Zoom participants. Okay, from the from Zoom also we do not have any questions. Okay. Okay, so well, ladies and gentlemen, thank you to all participants for your support and cooperation in the Q&A session and the presentation just now. Okay, we will share with you the email address of the panelists in the chat box so that you may ask questions directly should you need more explanation. That wraps up our session for today. Okay, on behalf of Darul Hikmah Library, we would like to thank you all for making time in your busy schedules to join us for this webinar on Stop Piracy and Safe Copyright. Before we end, do not forget to subscribe to the official IIUM Library YouTube channel and click the notification bell so that you will not miss out any interesting events or content uploaded. Now, let's take a group photo. Participants may turn on their cameras and are recommended to use the program background provided. Okay, moment ya. Okay. Okay, so we have two screens here. Okay. So okay, on count to 3. Okay, sedia ya semua? Can we have the participants to turn on their camera? Okay. So on count to 3, sekejap 1, 2, 3. Okay, next page. Okay. 1, 2, 3. Alright. Okay, once again, thank you so much, Encik Shafiq, for the very beneficial presentation. Okay, we would like to express our heartfelt gratitude to the respected panelists and participants for your presence. We would like also to apologize for any shortcomings and inconveniences. Hope to meet you again. Wish you all a pleasant day and stay safe wherever you are. Let's end our session with the recitation of Tasbih al-Kafarah and Surah Wal-As. Okay. With that, wabillahi taufiq wal hidayah. Wassalamualaikum warahmatullahi ta'ala wabarakatuh, and thank you.
Terima kasih Cik Shafiq. Assalamualaikum.
Terima kasih Cik Shafiq.
Thank you very much.
Thank you very much.
Sama-sama.